So, welcome to this second panel, which I think will have a hard act to follow because considering the level of presentations of the first panel, it's going to be more difficult to keep up the same level, and also because of time constraints. I mean, when I was preparing for this panel, I had written down all the times that were to be allocated to each speaker. That has gone overboard now. Of course, we can always blame the Pope, and you know why. Gregory XIII, the Gregorian calendar, 1582, he should have put more hours in a day, really. But anyway, we can't do better. So the topic is role of the judiciary in the modern era and promoting independence of judges. When I see that second part of the title, my mind goes to the issue of how much and to what extent can judges themselves promote their own independence through judicial pronouncements or through public pronouncements. If through public pronouncements, of course, the idea of a second Barca against Hungary, raises its specter, as it were. So I'm eager to hear what our panelists have to say on the whole topic. And the first speaker is President Valentina Pavlicic from the Supreme Court of Montenegro, and unfortunately she will have to leave us immediately after her presentation because she has another official engagement here in Nicosia. So I give you the word, Justice Pavlicic, okay, and you have 10. I'll try and, well, be the gatekeeper and keep you, as soon as you reach 9 minutes, I'll make some gesture from over
okay.
here.
Yeah. Okay, thank you, Chair. For us in justice system, it's not need to repeat the time. We are very shortly. Ladies and gentlemen, dear colleagues, it's really my professional satisfaction and also personal to be today part of this esteemed academic event, and especially speak about very important topic such as judicial role in defending of the judicial independency. In addition to discussing principles, this is also an opportunity to review our common obligation, which is to protect the foundation of justice on which every democratic society rests. Judicial independency is not privilege. It's our oath, our promise, our vow. It represents a promise that the judge, guided exclusively by law and conscience, will be held to every individual who comes before the court seeking for protection, security, or truth. The independence of the judge is a quiet but unshakable force that prevents power from overriding the law and interests from displacing justice. That is why our role as judges is as demanding as it is honorable. We are the guardians of trust, which is not earned by a single decision, but by an entire working life. Justice is value that must be a living instrument, confirmed daily by the action of those who are called to implement it, and it is implemented by independent judges. And justice must not depend on the current political situation, current political winds, but exclusively on the law and human dignity. The judge, in that high role, should be a beacon of truth and impartiality, immovable in the face of storms of pressure, consistent in applying the law and open only to arguments based on facts and legal forms. This does not mean his separation of society, but on the contrary, we serve the society in best possible manner. Integrity of judge is not professional duty, but it's moral vertical that preserves public trust in judicial system. When integrity of the judge is unquestionable, then the final judgment is more than formal act. It becomes a symbol of the trust which society places in its justice. That's why integrity and thus independency is defended with every action we take within the institutions when we advocate for transparent procedures with every decision and every word spoken in the courtroom. Impartiality is the heart of independence of the judges and judiciary. Without it, law loses its force and justice loses its purposes. In the time of fast information, intense public surveillance, and frequent unargued attacks with the character of populism, the word of just must remain measured, dignified, free from political influence, emotion, personal interest, and all forms of inappropriate influence. Only in this manner can the judge's word have authority and judge's decision moral and legal weight. Dear colleagues, defending judicial independence is not simple act. It's a daily effort, a struggle that is quiet but also determined, in which the judges play the biggest role. Each of their actions confirms that independence is not only a principle, but also a living case law. Judicial independence is most precious pillar on which of the rule of law rests. It's like a light that illuminates the path of justice, protecting judges from the shadow of political influence, interest pressure, and social turbulence. Only a judge who is truly independent can make decisions that are true, fair, and free from any form of bias. Independence gives the judge the courage to pronounce a decision even when it is not popular, and the strength to remain faithful to the law and conscience even in the face of the most difficult challenges. He is the guarantor that the law will be equal for everyone. True judicial independence lives not only in the law, but also in the character. It is built daily in the manner the judge approaches the resolution of the dispute, in his calmness, in the measured manner he speaks, and in the dignity which he preserves his office. Independence is the power to remain faithful to the law, but also the wisdom to always be open to arguments. It is quiet but steady force that allows society to believe in its institutions. When the judge is independent, then justice stands tall, and society knows that the law has its inviolable home, the courtroom where everything is subordinate to the truth. In a time when justice is often put in the test, it's our duty not to back down and to stand up for the rights of every individual, the values of society and future generation. because only independent judiciary can guarantee what is the core of every fair society, that everyone has the right to be heard, protected, and will be equal before the law. Today, more than ever, international standards represent an important compass for the action of every judge, in the whatever national composition they judge. These standards are not imposed, but arise from universal values shared by democratic society, and respect for them does not diminish our independence, but confirms it, putting us side by side with countries that nurture a culture of legality and protection of human rights and basic freedom. Least but not last, I want to share some concluding remarks by my side from this panel, and where we live in the era of populism, where too loud politics sometimes silence judiciary. With all its honorable action, judges confirm that independent judiciary is the highest expression of the rule of law and the most reliable guarantor of equality, freedom, and dignity of every individual. May this symposium encourage us to renew our commitment to defend judicial independence, not only with the words, but with the power of our action, and our actions are well-reasoned judgments, and to preserve justice as the greatest good that society can have, because only an independent, responsible, and professional judiciary can guarantee what is the core of every society. That justice is not only sought, but is also achieved. That the law is equal for all, that no one is above on the law, and that the court is the last shelter of the justice. Thank you.
Thank you. Thank you, Justice Pavlicic, for that, well, really inspiring talk, because you also went into the question not only of independence, but also of impartiality, which, can be subjective or objective, but above all on the question of integrity and, the behavior of judges on and off the bench, which is, I think, very important also for, public perception, perhaps sometimes even more important than the rules guaranteeing the independence of judges. Thank you very much again. And now, if you need to leave,
yes,
you're welcome. So the next speaker on the list is Professor Amnon Reichman from the University of Haifa. Here we go.
Thank you. Okay. Wonderful. Thank you very much. Wonderful to be here again. 10 minutes, let's say indeed a bar to meet. So this is what I have to do in 10 minutes. This is the introduction. We're going to talk a little bit about decisions and judgment, a little bit about AI, the three main challenges, and then some recommendations. So I wanna tie us back to the central, or one of the central meaning of judicial independence, and that is independence with respect to decisions. So judges do a lot of things, and public trust in the judiciary is not just a matter of decisions, but decisions are very important. So we just heard about judicial character, judicial behavior, integrity. This goes way beyond the notion of decisions. It reflects on judgment beyond the judgment on decision. But I want to focus on judgments with respect to decisions, and decisions not only judicial decisions, as we know, decisions with respect to appointments, decisions with respect to caseloads, logistics, there are decisions, but also judicial decisions. And the idea is that we want to protect judges from undue pressure. Now, when they exercise decisions, there used to be times, that this is for 20 years now, been going on, so in some periods of time, we focused a lot on what does it mean to have independent judgment, because this is a really difficult question to ask. What is independent? Independent from what? And what is judgment? There's a lot of literature that deals with how do people judge and how do judges judge. And we know that basically judgment is a sense. There is knowledge, there is rationality, there is emotions, emphatic emotions. We empathize, and then we judge. We know that there are experiments that if we have something wrong with our brain, we cannot make some decisions. We cannot know which sweater to wear because we don't feel things that we should feel. It's a very complex issue. I don't have time to get into that. It's just to say that judgment is a sense, and technology can help. Because we're human, we have some capacities, but we also have some vulnerabilities, and technology can help us. Let's focus on the particular technology at hand, and that is AI. We've heard about AI, and we heard Pascal earlier in the morning talk about AI. I want to go a little deeper into the notion of AI. Part of my work now has to do with the regulation of technologies. We can deal with it in the Q&A. So what's unique about AI? Again, I'm sure everybody knows this, but what AI does, it's actually large language models that are generative. We call it AI, but people from computer science would say, what? It's not artificial. It's artificial to the extent that all technology is artificial, but of course it's not intelligent. There's a huge data set, and you run algorithms on the data set to predict the next data point. That's what you do. The next data point can be a word or a sentence. The next data point can be, what will the law say about this? How would a particular judge decide about this? What should be the next policy? It doesn't matter. It's large data sets. You run statistical analysis, and then you develop further data points, and you learn. Because if you get it wrong, there is a feedback loop that says, it's like a game. No carrot for you because you didn't learn right. A better algorithm does it better, so the algorithms adapt. This is the idea of machine learning, ML, machine learning. Okay. This is what it does. It's very effective. It has the ability to serve. It's very effective to do some things. Language, for example, writing sentences. So it can improve efficiency also in the production of judgments, because there is a production line. The judiciary provides services. At the end of the day, it's a service, and you need to be efficient. So all the people in judicial councils, they care about efficiency, and that's important, and AI can help. It can help lawyers, it can help judges, it can help bureaucrats manage the system, it can help lawmakers make better laws, but it is also important because of our vulnerabilities. We have heuristics, we know about our heuristics, and technology can allow us a little bit to self-correct, but it has a lot of risks. It can hallucinate, create false facts, because it's not fact-bound, but we can mitigate against that depending on the data set. So we can make a closed data set, and then we can correct against hallucinations. There is a danger of calcification, past looking, because it predicts based on the past. But what if we want to change the past? We will just get again and again. It's very important with respect to biases and equality. So if we have an unequal system, we'll keep having the same biases again and again because it's reflected in the data. It doesn't have the emphatic feature of seeing the particular person, not the abstract review, but the particular cases where you have to actually see the people, and we don't understand it. There is an issue of opaqueness. We don't understand what's going on, and that's a problem for due process. I don't have time to get into that. The way to solve it is, as we see in the Mount Scopus ELI, or should I say ELI Mount Scopus principles, there is a section 23, and section 23 basically says there has to be a human in the loop. You cannot delegate the power to make decisions when they are legal decisions. Some bureaucratic decisions maybe, but legal decisions you cannot fully delegate to a machine. You have to have a human in the loop. I want to say, with all due respect, that this may not be enough. Why? As stated, it may not be enough. Why? Because of three main challenges that AI generates. And they all actually amount to questioning what is to know. The notion of knowledge, the very notion of knowledge, is now being challenged. So today, but in the next 2 years or so, it will become very difficult to know what is authentic, because AI can generate replicas of things to the extent that it would be very difficult to know what is AI generated and what is non-AI generated. So you have a cat and mouse now, that AI is, or technology is used to detect AI, but then AI learns about the technology to detect it, so it self-corrects, and then it's a cat and mouse. It will become increasingly difficult to know whether something is a deepfake or not a deepfake, whether what is authenticity. And it's not me who's saying this. It's the people from the technology, Sam and others, who say, watch it, it's really dangerous. The second issue is it's not just AI in the abstract. We mentioned the Romanian cases about the use of AI. It's EI, it's emotional intelligence, in the sense that some of the data points are how human reacts to certain information. What makes us angry? What makes us bored? What makes us sad? What makes us want to purchase something? This kind of music, with those images, I need to go to Nicosia. Okay, where do I buy a ticket? There is money behind this. It's not just done for, oh, this is an interesting, there is commercial interest behind it. So we are manipulated in ways that are, because we're vulnerable, in ways that are very, very difficult to detect. What makes us angry is a clickbait. So we amplify what we talk about becoming very polarized. Why? Because when we're angry, we want to know more, and we are motivated to stay online. Whereas with respect to other things, this is not really important. Don't worry about this. This is more interesting. So because this is boring. Maybe this is really interesting, but we don't want public discussion about this, but rather on that. Look, there's a bird here. Don't look at this. So the emotional manipulations AI can deliver very effectively. And last but not least, the degradation of capacities. AI, I don't know if some of you may have heard of TikTok. Some of you may also be on TikTok. It's very addictive. Why is it addictive? Because it knows what you want to say. Oh, this is the little next. My kids are, if I want to withdraw TikTok from them, they go like, oh, I'm missing something, like somebody took a finger of my, like, where is the TikTok? I need to. So because it knows what you would expect, and there's a dopamine working, and we tend to rely more and more seriously. We tend to rely more and more on technology. We have research on cab drivers in London. Part of the brain is really developed the idea of where to navigate, because they always keep, okay, if this street is blocked, I need to go from there. And this, we lose this when we use Waze or Google Maps. So there are capacities that we lose. Yes. So some capacities also are related to judgment. Because when we delegate things to the machine, we wait for the machine to tell us, what should I do here? What movie should I see? Netflix tells me, that's the next thing for you. Oh, thank you very much. The more we do this, the more reliant we become. We may lose capacities. When we use Waze, as I said, we lose the capacity to navigate, and that's a danger. So what is to know becomes problematic, and therefore, when we talk about judicial independence, and I have to conclude now, we have to allow judges a degree of independence in configuring what counts as judicial knowledge. And when I look, and here this is my final point, when we look at the way that the Section 23 is written, it says, and here are my modest suggestions to for better, we're lawyers at the end of the day, so the way how it's written is important. So some modification. The judiciary must, so far as predictable, oversee the development. No, the judiciary has to have a role in the table for any technology that is used in the court. not to the extent practical. This is how Section 23 is. If there is a technology that is used, judges must be there to make the decision and fully aware of the consequences, including logs that who touched the technology, etc. And the second point, and even more worrisome, is the next segment here, section number 5. The judiciary must be properly trained. This is a passive language. Who trains the judiciary? We don't know. The judiciary must train itself. This should be written in an active form. The judiciary must train itself. Otherwise, corporations will train the judiciary. And, you know, judiciary is not just from other branches and not just internal independence from bureaucratic power from the judiciary. Judiciary is also independence from the parties, but also from civil society at large, like big business. So that has to be factored in today. So we need to experiment. We don't know enough. We need to keep experimenting, and we need to allow for information sharing between judiciaries. And that is something we have to work on. And I think this organization can play a very important role. Thank you very much.
Thank you, Professor Reichman, for that, can I qualify it, almost scary presentation. As you were talking, I was reminded, I don't know, the younger members of the audience here remember Space Odyssey 2001. Yeah, that's right, the name of the computer. I liked the medical terms, by the way. But one point that you definitely put your finger on, which is a very sensitive, I think, issue in many jurisdictions, mine included, Malta, is the allocation of cases and caseloads. It's perhaps there that I would like to see more, you know, technology helping in that rather than in the drafting of personally, as a retired judge, I'm still very happy to use parchment and quill, so without the use of AI. But anyway, that's me. Thank you again. So now we pass on to the third speaker, and that's Professor Gralf Peter Kalis, if I've pronounced the name correctly, from the University of Bremen. Correct me if I got it completely wrong, Professor.
Thank you very much, Chair, and thank you also for having me at this conference. And as I am a private lawyer specialized in private international law and commercial law, I asked myself, so why are you having me here? Or you may ask yourselves, I'm teaching also the introductory class for our first year students to the history, philosophy, and sociology of law, and there's one section about the judiciary, about the courts, and that's 90 minutes. So now I have to be a little bit more brief, I guess. And the good thing is that this morning already we had one presentation by Matthias who already said a lot of things I wanted to say. And I think everything you said, more or less from my point of view, was correct, especially about the rule of law and the problem of that it shouldn't become a rule of judges, as Ernst Forsthoff in the 1960s in Germany, a scholar, said, vis-à-vis the constitutional human rights jurisdiction, which is extending very much, or even then was beginning to extend very much into the realm of, former realm of politics. And after 85 years later, no, 65 years later, you could say that has gone on and on. One thing I think is not correct, judicial independence, the concept was not invented in French Revolution, but in the 1701 Settlement Act, so by the British. Okay, and they said judges should stay in office during good behavior. So that was a big advantage, so they didn't hold office only as long as the king held office, but themselves got lifelong tenure as a king. So that was the starting point, I think. But when we are talking about judicial independence, I think it's a problem always if you over-specialize. So here, with all these organizations talking about principles of judicial independence, what I miss a little bit is that I think it's a constitutional trias, not at least. So it all started off with Magna Carta, where King John promised to no one will I sell, to no one deny or delay, right, or justice. And so I think the first very important point about keeping the peace is that everyone has a right to a remedy or access to court, however you want to call it. And a big problem in the last year conference proceedings I received by Nicholas, and it was on delay, the problem of delay. And then we have judicial independence, and in Germany, or in other countries as well, the natural judge. I think the French say it. We say the tribunal established by law, in the words of Article 6 Convention of Human Rights. All these three principles, two of them in Germany at least, are fundamental rights of everyone. Like you have a fundamental right to access the court and a fundamental right to be judged by your natural judge. But then judicial independence, there's no fundamental right for the individual, but it's basically a right of the judge, or, and that's a big question, is it a right of self-regulation of the judiciary, of the third branch of government? And I'm not so sure about that, because very often what I hear by these discussions, especially when only judges or judges associations are involved, then they think they should self-regulate themselves. But we in Germany are a little bit skeptical about that. And it has some reasons which, and I want to give you the perspective. In 2013, I was asked to give an expert opinion for the Deutscher Juristentag, which is a meeting of all lawyers from Germany, and they give political legal policy recommendations. And the question was, just to give you one example, the court statistics in Germany of the civil courts entry level said that in 2001, the duration between a claim coming to the court and a decision was 6 months. In 2013, it was already doubled, 12 months. And in the higher courts, it was doubled from 10 months to now, I don't know, 18 months or something. And then the question was, why? Why is it just doubling? And I think we have to, and it's a big problem of delay, access to justice, right to a remedy. And then the question was, is judicial independence, if misunderstood or overinterpreted, is one cause of delay? And I think it's very obvious. I take it from a presentation of Lord Scruton in 1921 in Cambridge. He was a Lord Justice and so on, very famous and experienced. And he referred in his presentation on the work of the commercial courts to the 18th century already, so briefly after the institution of judicial independence, that people, especially many people who want to go to court labored about the London courts, which started to sit in the morning, and then they interrupted the sessions for lunch break, and then at 12. So then the judge would go with the barristers together, and the barristers paid, of course, to lunch, and they had one bottle of French wine, I guess, and then a second bottle, and then they never came back. So, so it's very old. So it's always the same thing, you know. So in the London courts, obviously they work 2 hours per day, and then nothing happened because they were too drunk to resume sessions afterward in the afternoon. Another thing is just like this is anecdotal evidence, but we introduced in Germany to have certain registers, the commercial register online, okay? And then there was a judge in Bremen who said, no, I'm not going to work with a computer, And I'm not going to have a computer on my desk and then referring to the electronic commercial register. I'm asking you, the president of the court, to have all what I wanted to print out and put it on my table. And he was referring then to judicial independence as an individual right to, and that went up until the highest courts. So he wasn't successful. Well, this is just some examples that too much judicial independence, I mean, as well as in Germany, at least the professors have lifelong tenure, you know, and some of us never publish anything after they got tenure, you know, that's quite, it's difficult. So you need these kind of freedoms as judicial independence, because we were talking about that, but there are also limits in this. And especially if everything is self-organized, then the ministries of justice, who are somehow responsible at the end of the day for delivering justice in time, they cannot always, the judges always ask for more, we need more judges and so on. But the question then is why, without any material change, you could find the time went up from 6 months to 12 months, for instance, in the, with the same cases they treated, so in Germany. And for that reason, I think we have to keep in mind these trias. It's like right to a remedy, judicial independence, and natural judge. And as all of these trias, which I call, it's the constitution of the legal system, so it's law, constitutional law, if you want, they are also constitutional principles. And we know from constitutional law that there's no constitutional principle which is just like applicable like that, but you always have under the principle of proportionality, you have to find a compromise between colliding principles. So that's not just, and that's, I think, is a very important point to keep in mind when discussing this. And how much time do I have? Not much, but I want to give two more examples, which are, there's another very famous and fundamental principle of justice saying, nemo iudex in sua causa, okay? For obvious reasons, because you're not independent or impartial if you're just adjudicating on yourself or your peers. And so the problem of the principle of judicial independence is if you complain as a judge, it goes up to the judges again. And it goes up and up and up. And then, okay, judges, I call it adjudication on adjudication. It's reflexive. I don't know how to avoid it, but it's a problem that judges judge if they are too lazy. You know, that's a problem. One last problem I just want to strive on is you said the rule of law says the most important thing of the rule of law was that even the king is not above the law but below the law. So then you said the rulers should follow their own rules. And I think in all this, what happens in Eastern Europe, we discussed this morning also, a really big problem is that the European Court of Justice is not a court by its, if it would apply its own criteria on what constitutes a court, impartiality and so on and so on and so on, by the same criteria. Why? It's very obvious, because the judges are elected for a limited time period and they can be re-elected. So you can punish them or give them a carrot. And it's for an American. I was on a conference with Eric Posner. He was saying, well, it's ridiculous, this system, and no one really, I don't know. I think this is a thing we should keep in mind also in the discussion. Thank you.
Thank you very much, Professor. It's actually, you touched upon two issues. One of them is the term of office of a judge and the possibility of reappointment. I should, as you probably know and everyone knows, in Strasbourg, of course, that's not possible. One mandate and that's it. Now, because previously it was different. And secondly, also for taking us back to the issue of, yes, the security of tenure. You know, judges holding office quam Deus bene gesserint, as the saying was. The issue of self-regulation was very topical in Malta in the just before I became a judge, when the question was what powers should be granted to the Commission for the Administration of Justice. And there was one judge, only one judge out of a cohort of 14 or 15 at the time, who actually, once that the law was passed setting up this commission, simply refused to go to work. Because he said, now I am under the supervision of an institution which is not entirely composed of judges. And we had quite a lot of problems with that particular case. Thank you very much for that. And now I call on the next speaker. That's Professor Takis Tridimas, who I believe is online. And can you hear us, Professor?
Thank you very much.
Yeah,
Yes,
you have the floor. Thank you.
Thank you very much. First of all, thank you for including me. I am particularly grateful to Simon, to Professor Sistrid for including me in this. It's an honor. Thank you also for tolerating my taking part remotely. I wanted briefly to address these three issues. First of all, say a word about the importance of judicial independence. Secondly, say one word about liberal democracy. And third, share some reflections about the role of courts, in particular, this idea that instruments of international law or constitutional texts or the European Convention of Human Rights are living instruments. I had the benefit of following some of the previous session, and I'm really express admiration for the previous speakers, both in the previous session and in this session, and I thought I could perhaps reflect on some what has been said. So, importance of judicial independence. Why do we need it? I think we need it for a number of reasons. First of all, it is an integral part of the separation of powers. Unless courts are independent, then there is no separation of powers. Secondly, because the right to an independent and impartial court is the gateway to all other rights. There is no point in having freedom of expression or the right to security or the right to property unless it can ultimately be guaranteed by an independent and impartial arbitrator. Thirdly, because I think judicial independence is inherent in the conception of the judiciary in a liberal democracy. The idea is that there has to be some oversight over the political process. And the system of separation of powers, as I understand it, juxtaposes, if you wish, the impulses of the political decision-making process with the rationality of the adjudication process. Political decision-making is not rational. It depends on all the vicissitudes of the democratic game, of the political game, and we need to have some kind of oversight, which is what the courts provide. And to do that, there is a lot of formalism. There is a procedure. There are certain remedies. There are limits to what the courts can do. And that system, it seems to me, presupposes the independence of the judicial decision maker. I view courts, especially courts that apply public law, but even private law, they are a form of intermediaries. They're a bit like Prometheus. In the ancient tragedy, Sophocles juxtaposes the power of the gods and the intelligence of the humans. And throughout the tragedy, this juxtaposition is very clear. And I think this is what the courts are doing. They're intermediating between political authority on the one hand and certain values, certain rights that the Constitution guarantees for the citizens. We all agree that freedom of expression is a great idea. We all think non-discrimination, yes, very good news. And abstract character of these principles is both a strength and a weakness. The strength is that it enables all of us to come together, irrespective of our political affiliation. The weakness is that not all of us draw the same conclusions from these principles, especially because they often contradict itself. So we need an intermediary, we need the courts to resolve these disputes, and independence, I think, is a sine qua non for their legitimacy and their ability to do so. But I think there are also additional reasons why independence is so important nowadays. I think it is increasingly threatened, and I think that was illustrated very well in the previous panel. Professor Piana explained it by reference to various reports of independent bodies. And I think we do experience some regression of rights. So I think the courts are essential there to keep the balance. It seems to me that there are three narratives against rights. First is what I call the majoritarian narrative, and Professor Storm, I think, articulated it. The idea that we have too many rights, we should leave more things to the majority, ephemeral as it might be. So that is an anti-rights narrative based on majoritarianism. The second narrative is the supranational narrative. The idea here is that it's fine to have rights, but they should be given at the national level. We have too many supranational rights. And I think there is a third narrative, which is essentially more fundamental. The idea is you should not have democracy. Not everybody shares the idea that we should have a set of values that bind the political authority, or a set of rules based on majoritarian decision making. North Korea or China don't believe in this. And I think there is all these three narratives. They come from different perspectives. In some respects, some of them overlap, but I think all of them have led to a feeling that what post-war European democracies cherish is under increasing threat. And also they have led to a degree to a regression of rights. So I think that makes the role of the courts perhaps more important than ever. In the context of, I believe that the European Court of Justice, as indeed the European Court of Human Rights, have played an enormous role and a beneficial one. This is not to say that one cannot take issue with specific judgments. Allow me to highlight 2 points that were hinted at or discussed by previous speakers. The duration of tenure for the members of the Court of Justice of the European Union is based on the principle of renewability. They can be renewed every 6 years, and I agree that that is not satisfactory. To my mind, a longer non-renewable term would be better. We have to bear in mind here that there are historical paths of dependency that sometimes make it difficult to introduce optimum rules. But I entirely agree that this is problematic. Also, again, so far as my view is worth it, I have some difficulty with this principle of mutual trust, which the European Court of Justice has elevated to a structural principle of EU law, in accordance with what the written text dictates, because it's not, I don't think the Court of Justice got it out of thin air. It is in the treaties. The idea of mutual trust being that sometimes the judges of one member state must trust that judges of other member states are independent and impartial or comply with fundamental rights. And it seems to me it can be justified, perhaps or at a technical level, as a rule, if you wish, of private international law, although that is not the legal basis of it in the case law. It could be justified, but I have some difficulty with the idea that a judge can outsource the protection of fundamental rights, even if it is to a fellow judge from another jurisdiction. A second topic where perhaps I can say one word is this idea of liberal democracy. And all I wanted to do here is mention simply that the European Law Institute in July 2024 published a set of principles, a charter of fundamental constitutional principles of a European liberal democracy. This includes the principle of judicial independence. In Principle 14, we are fully aligned with the much more detailed and impressive work that has been done by Shimon in the in the ELI Scopus standards. And I think even though the Charter of Fundamental Constitutional Principles did not refer specifically to every fundamental right, we assumed that we took that by way of incorporation by referring to the European Convention. The right to judicial independence, the concept as a constitutional principle is so fundamental that the working group felt that it merited a specific mention. So it's also an opportunity to thank Professor Pishonas, who at that time was the president, and also Professor Wenderhorst, who at that time was the scientific director of the ELI, for conceiving that project. So let me then see.
Could I ask you to try and come to a conclusion?
Certainly. Thank you.
Thank you very much.
Just one word about constitutions being living instruments. Well, I think we need to be very careful in decoding what courts mean by this expression. This idea of evolutionary interpretation of the law, I think needs to be unpacked a lot more. There is in fact only one case in the history of the European Court of Justice where it has referred to the Charter of Fundamental Rights as a living instrument. It is terminology which is used a lot more by the Strasbourg Court, of course, but I think to pass a judgment as to whether it is a legitimate way of proceeding, one needs to think what would have been the alternative methodology or the alternative ways of proceeding. Just by way of example, that's my last one. If we look back at the Edwards case, 1929, I think, Privy Council of the United Kingdom, the issue was whether the term persons in the Canadian Constitution included female persons for the purposes of elections to the Canadian parliaments. If someone can be a woman and be a deputy. And until then, there was absolutely no doubt that it only referred to male persons. The Privy Council changed it. Let us remember that what in one era may be thought of as impossible, in another era may be unavoidable. So I think we need to give the courts a bit of leeway on how to make constitutional texts relevant. Thank you. I will leave it here. Thank you very much for having me once more. Thank you.
Thank you, Professor Tridemas, for participating. in this discussion. Thank you very much indeed. You actually highlighted one important issue, that is that whenever there is some form of narrative as to what we mean by independence, that narrative has to be quite clear. And you mentioned, for instance, the separation of powers. I mean, people of my generation were brought up on a regular diet of separation of powers, taken, of course, piecemeal from the writings of Dicey, Albert Van Dicey, and these checks and balances, not realizing, unfortunately, that Dicey actually, his prime principle was the supremacy of Parliament. In the United Kingdom, the Parliament can make a woman a man and a man a woman. So I don't know how much, checks and balances were inherent in that kind of theory. But thank you again, Professor, for highlighting this issue. Now, on my list, I have Professor Stephanie Chelou from the School of Law of the University of Central Lancashire, Cyprus, online. Thank you, Professor, for taking the time to participate in the symposium, and I give you the floor.
Thank you very much, Mr. Chair. Hello, everyone. Sorry for being online, but like Takis, I couldn't be in Cyprus at this moment. I have been listening very carefully to previous speakers, including the previous panel, and I find the discussion extremely helpful, fruitful, but also extremely detailed. So thank you for the invitation, and thank you to Nicolas and the organizers for actually tackling the topic, which is a broad and very important topic. Well, I only wanted to share with you a few thoughts on the upper level, on the role of European judges overall in times of crisis and in times of emergencies, and how upholding the rule of law in Europe is done via the principle of judicial independence. And remind everyone that basically judicial independence of the European judiciary has been in transformation in the past 10 years or so to address current challenges and threats to judicial independence. And I would agree with other speakers, of course, that without full judicial independence, and I would add at all levels, there can be no effective rule of law protection, as well as democratic values and human rights protection. For this, I just want to go back to some of the landmark cases of both the Court of Justice of the European Union as well as the European Court of Human Rights, particularly going back to the idea of the European judiciary, and maybe offering some answers or some elements of answers to the questions that Professor Tridimas and others have actually put. If you go back to the Portuguese case of the Court of Justice of the European Union, which is an extremely important case, particularly paragraphs 37, 14, 41, I'm just quoting very briefly. The court actually states that every member state must ensure that the bodies which as courts or tribunals within the meaning of EU law come within its judicial system in the fields covered by that law, they meet the requirements of effective judicial protection. With that case, it has been argued, and I think quite agreed, that the EU has moved on from maybe a little bit more abstract effective judicial protection principle to a principle of judicial independence of the EU judiciary as a whole. So it's interesting to look at the EU judiciary or the European judiciary and see who actually composes it. So ideally, the EU judiciary also includes national courts on the basis of the effectiveness of EU law and the duty of sincere cooperation, because part of the role of national judges is to operate as decentralized EU courts or union judges. And I think maybe that can offer some answers to the questions we have here. Looking at the Advocate General's Bobek's opinion in the case of Procuratura, it's interesting to look at the way he sets out the fact that it is vital for the European judicial system, and I quote, to insist on minimal guarantees of judicial independence and impartiality for all its constituent members, irrespective of whether in the individual case before a given court, EU law is in fact being applied. So we basically see the formation of not only an EU judiciary in terms of judges and actors, but also an EU judicial space. This is something I have explored in a working paper that I wrote together with Dr. Veraldi that you can find online, and I would be happy to provide it if that can be of use. So the Court of Justice of the European Union has basically used Article 19, paragraph 1 of the EU Treaty to establish a more general obligation for EU member states to guarantee and respect the independence of their national courts and tribunals, also on the basis of the second paragraph of Article 19, paragraph 1 of the EU Treaty. And as a result, it can be argued that member states can be found to have failed to fulfill its treaty obligations by violating the principle of judicial independence, and I think we have examples of this already, via infringement proceedings, example against Poland, on the basis of Article 19, paragraph 1, second subparagraph, but also via the rule of law conditionality mechanism, if you look at the past judicial history with Hungary. So there is, in the past 10 to 15 years, a proliferation of cases raising issues of judicial independence from national courts in many EU member states, not only Poland and Hungary, mainly under Article 19 of the TEU, which requires both arms of the EU judiciary to be independent. And here we can also use Article 19, paragraph 2, third paragraph. The advantage of looking at Article 19, in addition to the provisions of the EU Charter on effective judicial protection, is of course the scope of Article 19 of the EU Treaty. Whereby by using Article 19, you do not need to meet the hurdle of the member states acting within the scope of EU law and of the Charter. As a result, there are a number of what we call fundamental or essential guarantees of judicial independence that have been developed at the EU level, and these include guarantees around what has been discussed already, irremovability of judges, commensurate remuneration, particularly austerity measures, but also real reduction in salaries vis-à-vis judicial independence, but also the protection from external intervention or pressure in appointments, term duration, remuneration, and measures that cannot be discretionary or arbitrary with reference to political decisions, power struggle, or even the situation of Brexit that we had to face some years ago. And this is complemented by a rich case law, a body of case law from the European Court of Human Rights that also has developed a large body of landmark cases on judicial independence using several provisions of the ECHR, not least Article 6, paragraph 1 of the ECHR, the right to a tribunal established by law, Article 46 of the ECHR when there was a non-remedied situation, particularly in Poland, as well as Article 6, paragraph 1, when it comes to the lack of access to a court, Article 10 of the Convention on the Freedom of Expression, including of judges, as well as Article 8 of the Convention on the right to privacy and family life of judges. So again, there are other aspects that have been also developed by the Strasbourg Court. They include statutory independence, absence of outside influence, objective guarantees as to the career of judges. There is one case that is interesting because of the way the court has approached things in Strasbourg. It's a case of 2016, so it's not a very recent case, and the case of Baca versus Hungary, where the Grand Chamber of the Strasbourg Court actually found a violation of Article 6, Paragraph 1, the right of access to a court, due to the lack of judicial review of the decision to terminate the office of a judge prematurely following the entry into force of the new law, the new fundamental law providing for the creation of the Curia. And in that case, there was one particular quote that I wanted to share with you and finish with this, which basically states that the growing importance which international and Council of Europe instruments, as well as the case law of international courts and the practice of other international bodies, were attaching to procedural fairness in cases involving the removal or dismissal of judges, including intervention by an authority which was independent of the executive and legislative powers in respect of every decision affecting the termination of a judge's office. So there is a lot to consider in that quote, and a lot of the issues that have been discussed, including the separation of powers already, appears in that code. That makes me think that what we need to think about is what I call responsive judicial review in Europe, or responsive European judiciary, in response to a growing backsliding of rule of law principles, but also of democratic values and human rights protection. So just a couple of final words to relay what I just said, or relate it to what Professor Tridimas said just before, but also to relate to other speakers. I listened very carefully to Achilles Dimitriadis, for example. Looking at the multi-level European judiciary may bring some elements of answers so as to address challenges that were picked up already in today's conference. Particularly, it's a way to articulate a review of fundamental rights at the transnational level, and move away from the constitutional review constraints that we have expressed already, including the fact that some judges seem to be reviewing themselves, and perhaps give the true meaning to mutual trust in the judiciary by looking at the actual multi-layers of the European judiciary, as well as perhaps think about the preservation of the separation of powers in a more contextualized setting. So this is what I wanted to share with you. I thank you very much. I hope I didn't take too much of your time.
Thank you. Thank you very much. Thank you very much, Professor Chelu. Yes, you mentioned the Baca case, which thank you for that overview of the case law of the Luxembourg and Strasbourg courts. In connection with the Baca case, what people don't realize that case, it was so difficult to find a proper composition for the court to function, because many of the judges then who were balloted in the first place, to sit on the Grand Chamber, had known and even worked with the judge in a different life. And if you see the preamble, I think, of that Grand Chamber judgment, you will see all the various compositions that were, balloted, and everyone then abstaining from, because I knew him there, and so on. Ultimately, I was balloted, and the only thing that I remember was that I had once met him at a conference somewhere. So I went to the president of the court and said, should I abstain as well? Of course not. You have to sit on that court. And finally, the hearing could continue and the judgment delivered. But I think you're already in place. Good. So now we have Professor Clerides, who will give us the final intervention for this setting. I thought you were Nicholas. Actually, next to me. I suppose he's got some announcement. No, it's you. Okay. Please,
Thank
you have
Mr.
the floor.
President. Thank you for the invitation. I thank the University of Nicosia. I will try to be very brief. I will give you my experience, not only as an academic, but also as a practitioner for the last 43 years, and as an ex-chairman of the Cyprus Bar. My speech will relate to the Cyprus experience, of course. I think that it is equally important to note that the perception of the public as far as judicial independence is concerned is equally important with actual independence of judges. What the public think about the judiciary may have extremely important effect on the independence of the judiciary. Where you have a country where the public does not trust the judiciary at all, the independence of the judiciary becomes of an academic importance. In Cyprus, in accordance with the latest scoreboard of the European Union, 1 in 2 question the independence of the judiciary. We are 8th from the bottom in the European Union. And I wish to contribute to the dialogue by suggesting that this rather poor score in Cyprus is the outcome of the judges themselves' behavior. Decisions of the judges, judgments of the judges, which have not contributed towards the confidence of the public in the judiciary. And I will refer to my experience in the last decade, starting with a very important case which related to the decision of the government to reduce the salaries of judges across the board, along with public servants, in order to cope with the budgetary crisis of 2013. The government just ran out of money. The Troika was here, and one of the measures taken was to reduce salaries of public servants and judges. Now, the judges objected to this, and some judges filed recourses before the Supreme Court to challenge the law which was enacted reducing their salary. Now, of course, the main objection was that the judges themselves of the Supreme Court could not hear the case because they were directly interested. Their salaries were also reduced. The court rejected the argument that they could not hear the case. They heard the case and declared the law unconstitutional. Now, this by itself created, I think, the wrong impression to the general public. But the worst thing was that after the judgment, the Attorney General of the Republic, who presented the case before the Supreme Court and lost it, made some statements in the Cyprus public corporation news item, accusing the judges of not being so sensitive to the problems of the country. Now this led to a public announcement, a public statement rather, from the Supreme Court condemning that. So it was probably the first time that we had this dialogue in public between judges, the Supreme Court, and the Attorney General. That was the first example I wanted to give of the judges themselves not being conducive to increasing their image before the public. The second case had to do with the law that the Parliament enacted to make judges declare their assets in the context of transparency, like any other officials, like members of Parliament, government ministers, the President, before they obtain office and after they leave, in order to make sure that no corruption issues arise. Well, it didn't go down well with the judges, of course. They didn't like it. And when the matter was referred before the court, again they declared it unconstitutional as infringing the separation of powers. The judiciary should remain entirely out of the rest of the public officials. Again, this created, I think, a bad impression for the public, that they did not want to be subject to the same rules as far as corruption was concerned with other civil servants. They opted for self-regulation. They said, we will do it ourselves. And they set up a mechanism, internal mechanism, to do it, which of course is not the same. The object here was full transparency, which was not achieved. The third case I want to refer to is a case of recusal of one of the judges, the president of the Supreme Court in 2019, who heard a case in which it was alleged that he has a bias and an interest which was not declared. He was hearing an appeal against the conviction of a senior bank official. The bank involved had proceeded with a haircut which affected the sister of the president of the judge. And yet the judge felt that, the president felt that he could hear the case, despite the fact that his sister was benefited by the bank in returning some money after the haircut, which was a unique and exceptional case. In all other cases, no money was refunded. And the appeal against the conviction of one of the senior directors of that bank was successful and overruled. The impression that was created, of course, to the general public was that there was a clear case of bias and that he should not have had the case. The other case had to do with the Auditor General. The Supreme Constitutional Court sat as a council, a disciplinary council, to dismiss the Auditor General for misconduct. It finally decided to dismiss him. The Auditor General was, and still is, a very popular figure in Cyprus, as a leader in anti-corruption procedures. He was dismissed, but that's fine, okay, that was a decision of the Council, the Supreme Constitutional Court, basically. But after that, there was an allegation that the ex-Auditor General, since he was dismissed, made a public statement that he heard that the decision was already taken at very early stages. And it was a case that was really arranged for this result. And the Supreme Court basically asked the Attorney General through a statement it made. It didn't actually ask him, but this was the insinuation, to proceed with contempt against the ex-Auditor General. This again created a public outrage because it was not enough that the Auditor General, who was a very popular figure, was dismissed, but now they wanted to punish him for a statement he made after his dismissal. That didn't go well, again, with the public opinion. And finally, the case that was referred to earlier by Mr. Dimitriadis about the judge on probation, her term of office was not renewed, apparently because the Supreme Court was dissatisfied with the judgment she rendered in acting as a coroner. She found that the case was a murder case, whereas the official government position was that this was a case of a suicide. Now, the judgment of the coroner went very well with the public, but the decision, of course, not to renew her term of appointment didn't go down well with the public. So I conclude by saying that in Cyprus, we have a mistrust as to the independence of the judiciary, not because of outside factors, but because of judgments and the attitude of the highest courts in the land. So this is what the two courts, the Supreme Constitutional Court and the new Supreme Court in Cyprus, have to look into and correct the situation. Thank you very much.
Thank you, Professor Klerides, for that. The cases you mentioned, I think, underscore the saying, I believe it is a correct English saying, that difficult cases make bad law. And that may be example. And also, I suppose that public institutions should not snipe at each other whenever there is the slightest, disagreement or something. As to the judges declaring or opposing the reduction in salary, but I say this subject to correction by either Professor Zelik or Professor Shetret. I believe that just after the First World War, there was a move in England, or a proposal, to reduce the salary of judges, symbolically, almost symbolically. And still the judges opposed it, forcefully, because of the principle involved. And I believe that eventually the government then engaged in, the First World War, withdrew that proposal. But I say that subject, so there is, in a sense, a precedent for the opposition of, touching the judge's salary, even in that case.
The argument was that the judges are not His Majesty's service, in His Majesty's service. They are independent officers.
So there was.
This is the rule. This is the rule, that the judges are officers by law rather than employees of in Her Majesty's, or now it is in His Majesty's service.
Thank you very much. Thank you to all the panelists, and please give them another round of applause, because for these very interesting presentations. Now I really have to ask Nicholas. Oh yes. Do I have 10 minutes for questions? Any questions, please? And yeah. There's another mic here.
Can I actually say something while we collect questions, because I'm afraid I will have to go. I am at the European Commission and I need to go. But if Mr. Chair would allow me just 1 minute to share my screen to complement what Professor Klerides was presenting. We conducted a number of perception surveys in Cyprus around the functionality of justice and trust in justice. And I have 2 slides, if you want, I can share with you.
Please.
That shows, okay, thank you. That shows actually the perception in Cyprus vis-à-vis the perception in the EU plus. Can you see my screen?
Yes.
Okay. All right. So
from where I am, I can't read the words, though. You will have to interpret the colors.
yes.
Yes, but if I turn around, I'll break my collar, I'm afraid. So-
Okay. So just let me try to do it. Is
okay,
that
I can
better?
read it.
So basically, we have a number of questions that we asked, and I don't have slides for all questions, but just to share with you this result from the Center of Excellence for the Rule of Law and European Values. It shows you the perception of how effective the courts can be. And you see that here in Cyprus, we seem to have a more polarized view. It seems that in Cyprus, most people who were surveyed would think that somehow the courts can be somewhat effective. On the other hand, you can see that we have more polarized views about whether they can also be very ineffective. And this is at a higher level than the EU plus level. It's EU plus because the UK is involved as well as Israel. We surveyed these countries plus the EU. And the second one that I wanted to share with you is this question. It's about how feasible it is to take a case to court in Cyprus. And here you see that the practice of taking cases to court in Cyprus seems to be more widespread. You have a somewhat, it's okay to take a case to the court in Cyprus, which is bigger than the EU plus. But then again, you have the polarized view of another good proportion of the population, which finds it which finds it difficult to do so. And the last one is this one. Have you thought about taking a case to court but have not actually done so? And here you have more or less the same level in Cyprus and in the EU plus for the no, but you have a smaller proportion of people who actually will or have answered yes to the question as to whether they would actually go to court. I have a number of other slides, but I'm not going to share them now. But basically, the other slides, they only look at some types of corruptions and how, where, in which institutions corruption is most likely to have an impact. And I just wanted to report that the courts in Cyprus were perceived as one of the highest possible impact in terms of institutions, and this is bigger or higher than at the EU plus level. So somehow the overall picture seems to confirm what Professor Klididis has been presenting, and these surveys were done last year, 2024.
Thank you very much.
Thank you
very much for that information. Thank you. So the first speaker was over there. Yes, Professor.
Okay. I wanted to ask to Professor Tridimas a clarification. At some point he said 3 attacks to rights. The first one being the, what was it, majoritarian or counter-majoritarian. And then he said there's a regression of rights. Now, I don't see why there is a regression of rights if rights are decided by parliament instead of by judges. And the idea of regression of rights is also very ambiguous because it presupposes in a certain sense the idea that rights are gratuitous, that the more rights you give to people, the better it is. The problem is that granting some rights also always diminishes other rights. So it's not something which you can gratuitously add. It's not by creating new rights created by judges that all the other rights are not in regression. So I wanted to ask, to clarify a little bit how you see this relationship and this counter-argument.
Yes. Can you take that question before we pass on to the next question, Professor? Yes.
Sure. Thank you. Yes.
Thank you.
I agree that rights compete with each other, or at least they may compete. It is correct that you have, just to give an example, you can have new rights competing with old ones. A new right is, for example, our sensitivity to animal welfare, which finds expression both in legislative texts around various jurisdictions and even in constitutional texts. So I entirely agree with you that there is competition. What I don't think I agree is this binary juxtaposition between rights which are given by Parliament and rights which are created by the courts. In a state which believes that authority is bound, the legislature is also bound, and this is why we have constitutions which, in the overwhelming majority of cases, are entrenched, and this is why the constitution mandates an independent judiciary to interpret those rights. So this idea that somehow Parliament has overwhelming power, I don't think it reflects the majority of the political bargains around Europe. I appreciate that there are countries where parliamentary supremacy is the ideal, is the fundamental constitutional principle, but most parliamentary democracies essentially buy to the idea that the individual should be protected not only against the government but also against the majority. So I don't think it is the case that that the Parliament has given certain extremely well circumscribed rights and the courts have somehow manipulated them or expanded them. I don't think that's the case. Usually constitutional texts give to the judiciary unusually wide power to shape the law. I think that is the idea of a constitution. And I entirely agree with you that we need to enter into a debate whether a judgment is correct, a judgment is incorrect. And I also think that the courts are interlocutors. It's a very interdependence between the different branches of government is extremely important. But I think your question presupposes that there is somehow a very clear juxtaposition. There are set rights given by Parliament, and the Parliament can take them back at any time. Having said that, I agree with the comment that you made earlier to the effect that if we have too many fundamental rights, then that devalues them, and then that may lead to the oscillation of the law. To the extent that the Parliament cannot change the rights, there are some difficulties here. But I don't. But I think, as I understood your question, the basis of it is a very clear juxtaposition, which I don't think it exists.
Thank you, Professor Trilmas. I think we have time for the last question. I believe it was over there. Yes, thank you. Or last intervention.
Yes,
whatever.
Thank you very much. I'm Nicolas Motodos from the University of Bremen. And if I may ask my boss, Professor Callias, a question, it's more of a comment. If he believes that the concept of legal education has developed in Germany, despite its parochialism, this idea of Einheitsjurist, the uniform jurist, is probably better in the sense of promoting judicial independence already from the bachelor point when the student goes to study, they study with the ultimate goal to be prepared for judicial office, and whether that ingrains judicial independence in legal education. Thank you.
Professor Callias? You,
Maybe that's a comment. Yeah, thank you for that. But
do you have anything
it's
to add?
just he was referring that the aim of our educational system, law schools, is to prepare everyone to become a judge. So if they pass our exams, they have the ability to become a judge instantly, which is also bad because we have very young judges in Germany sometimes, like 25 or 24 years even old. So, but I don't, well, maybe I have never thought about the question if that aim supports the idea of judicial independence. I cannot say anything to that point.
Reserve question. Supplementary question.
A very brief comment about it as a little bit being external and internal to Germany. I think that actually the system of German education is crucial for independence of judges and predictability of judgments. It has incredible role. It is very difficult to assess the German system with ministers who appoint judges and so on. We think that there could be this political impact, but the mechanism which somehow makes this guarantee that judges are thinking in quite structured way, which is put into this whole process of German education, of this unit and then this unitary education for judges. And of course, the system of qualifications after it is a very important factor in assessing the whole system of German functioning of judiciary. But you have actually choice among very highly prepared lawyers with extremely well structured way of argumentation, which makes the system predictable. And I can compare with my own system, where it was one of the problems with assessing the functioning of judiciary, that because our system of education does not provide a guarantee for this structured way of argumentation and thinking, then we have incredible incoherent case law with very bad outcomes for perception of judiciary by people. So I think this is a very crucial system actually for independence of judiciary. Thank you.
Well, dear colleagues, thank you.